I'd now like to call PB 19-04, representatives from the city and the
Melissa Prince on behalf of the city of Albuquerque.
Good afternoon, Thomas Grover on behalf of Deb Brinkley.
Thank you. So what I'd like to do is, the board has had an opportunity to read through the documents. So we normally give you at least 5 minutes or so to present any information or share your some feedback with us. So we'll go ahead and get started. Stuart, would you like to go first?
Sure. Members of the board, I appreciate the opportunity to come here and speak on behalf of Deb Brinkley and why the hearing officer's report in this matter should be accepted. These cases that come before this board are serious. We're talking about significant adverse actions upon public employees. And while I think the hearing officer's report in this matter speaks clearly and is detailed and sufficiently satisfies the relevant just cause standard as far as why reversal is supported and to reinstate Ms. Brinkley, I want to bring attention to the seriousness of these matters. Actions like this by the city don't happen in a vacuum. They have profound effects upon public employees that come to work in service of their community and service of their city. And in Ms. Brinkley's case, as this report details, there are insufficiencies all around. From the notice that brought her into the acting director's office and put her on admin leave, to the period of time, the extended period of time that she was put on admin leave, the subsequent injury upon her by the city firing her. She lost her pay, she lost her health care. Her name was tarnished because at the outset of this investigation, the mayor himself made statements to the effect that she had somehow been embezzling animals for her own benefit. In fact, the mayor said it's inappropriate for a city manager to transfer city property to a personal nonprofit business. It's a conflict of interest, and that's why I put her on leave. All of these things that Ms. Brinkley was alleged to have done were not supported. It ultimately came down to this notion that she somehow failed to provide a statement in a compelled statement interview setting. What's disturbing is that, as the record in this matter reflects, this investigation was done and submitted on April 4th. And this supplemental inquiry about the nonprofit that Ms. Brinkley had been allegedly funneling dogs to didn't come from Director Navarez, it came from Ms. Coons. And yet this action persisted. It perpetuated. It kept going. For 6 months, the investigation sat on Director Navarez's desk, and no action was taken until November. We didn't know the investigation was done. We didn't get notice of it. Oddly, on April 27, 2018, and this is an exhibit in this record, I sent a letter to Sarita Nair, the Chief Administrative Officer of the city, saying, look, this needs to be addressed. There is no basis for continued action upon this employee. She's a good employee. Her heart is for the animals. It's not her fault that the department she found herself in is grotesquely dysfunctional to the point where we had a person lobbying for her dismissal who sought to have other employees sign a petition and present it to Mayor Keller. And the hearing officer is correct when she says that this case is steeped in intrigue and toxicity in the workplace, and a new city administration's embarrassment over an unflattering media report. And it certainly appears that as a result, every effort was made to remove Ms. Brinkley. And when they couldn't get her on the initial notice of charges, they tried something else, which we called them out on. They never called her in for another interview. They never sat her down. And as the hearing officer's report succinctly reflects, there is no just cause that supports discipline upon Ms. Brinkley. And obviously, even if there were some basis for discipline, the city has failed to show that any progressive model of discipline has been applied, or that any similar discipline has been applied to other employees of the same situation. And the last thing I want to emphasize, going back to my original statement, that these actions don't occur in a vacuum. You know, I was a sergeant with the Albuquerque Police Department. I resigned from this department. I put myself through law school because I objected to grotesque actions of misconduct by the former chief of police and the endorsement of improper conduct by deputy chiefs of police at crime scenes. Okay, so yeah, I may be a pain to the city, but I know what's right and I know what's wrong. And as a former police officer, I can tell you, I've been on the receiving end of calls at 2 o'clock in the morning when people don't have any hope anymore because their livelihood's been taken from them, their career's been removed, they're struggling to find out what job can I do to make ends meet for my kids. And the city's perpetuation of actions like this are the type of actions that result in tragedies. I've had those conversations with former city employees, and it's happened. And some of the people here are former city employees, and they know exactly what I'm talking about. And as we know, the city will not give up. If it doesn't like the outcome, they'll appeal the the board's decision. If it doesn't like a given hearing officer, they'll even move to obtain a restraining order against a given hearing officer. The reality is, you guys are the ones empowered to make a decision. I have faith in your ability to make a decision. My client has faith in your ability to make a decision. We have faith in the process.
Okay. Thank you.
And with
Mr.
that,
Earl.
any questions I can answer?
Any questions from the board just yet?
I had one with regard to the response from the city of Albuquerque, and specifically with the employee must cooperate. Can you respond maybe to what was alleged on that?
The allegation is that, and the landscape is this: a public employee, when they're a target or a witness of a given investigation, administrative investigation, is required to cooperate with the city for the furtherance of that investigation. That's the rough landscape of it. And Ms. Brinkley was scheduled for and attended a compelled statement interview. That's the cooperation with the investigation. Now, the scope of that investigation is related to the aspects of what's being investigated. They don't get an endless net to ask anything and everything about whatever they want if it's unrelated to the investigation. Ms. Brinkley goes to the interview, she attends the interview, she answers questions. Following the interview, the interviewer was a retired APD detective by the name of Doug Shaw. He contacted me, wanted supplemental information. We gave him that information. That interview was on March 1st. Over a month later, he sends me another email saying, at the direction of Director Navarez, we need to know certain information in addition. I responded at the direction of my client and said, first of all, you guys have most of this information. Second of all, information you're seeking may require consent of third parties. And third, who's giving this direction? He says, Director Navarez. I reach out to Navarez. What's going on here? Why are we having this thing? He doesn't respond. I follow up. He says, yes, it's a direction for me. Well, when we have our hearing, we find out that his direction came from Ms. Kuntz from City Legal. So our contention is that she cooperated with the interview. She answered everything to the best that she could. On the minor detail where she refused to identify a certain person's name, our position was that it was outside the scope of the interview. It was irrelevant to the allegations against her. And the city certainly could have taken steps to find that information in and of itself. And then lastly, even if for some reason it was determined that, yeah, she failed to comply with that aspect of the compelled statement interview, it certainly doesn't warrant discipline. It didn't affect the outcome of the investigation. It was inconsequential. So.
Thank you. I would like to object to Mr. Grover's statement to the extent that it references items outside the record, especially Mr. Grover's personal experience and any allegations regarding some sort of emotional trauma someone suffered. That's not part of the record, and it's not really before this board. And just addressing Mr. Grover's response regarding my involvement in the investigation, the city attorney's office oversees many investigations of misconduct, and as I'm sure everyone in this room knows, attorneys frequently act as arms or mouthpieces of their client. So to the extent Mr. Navarez asks me to coordinate something for him, I will do so. That does not mean the directive does not come from Director Navarez. The city disputes the hearing officer's recommendations on two sort of overall grounds. The first is that the city disagrees with her assessment of some of the evidence. And then the city also disagrees with hearing officer Durzo on some of the philosophical issues she raised. I'll attack the evidence or discuss the evidence issues first because I think they're the easiest. The first is that hearing officer Durzo makes multiple references to Director Navarez not even really knowing what Ms. Brinkley was disciplined for. If you go through the record and you read the transcript, it's clear that there's some confusion at the outset because the rule and regulation that Ms. Brinkley was disciplined for is entitled false statements and fraud. But if you read the text of the rule, it refers to withholding information as in part of an investigation. When, after a lengthy conversation, it does become apparent that Director Navarez, in response to the initial question, was referring to the title, but did in fact understand that Ms. Brinkley was being charged with withholding information. And the exact citations are provided in the city's exceptions to the hearing officer's report. The city also disagrees that there is substantial evidence to make some sort of finding of pretext. Mayor Keller's statements to the press elucidate a policy. Conflicts of interest are not tolerated, and they provide a status of things at that point in time. Ms. Brinkley is on leave. She was on leave. He didn't say that she's going to be terminated. He didn't talk about any sort of future action. And in fact, throughout the hearing, Danny Navarez did testify that no one discussed the decision with him. He wasn't acting at the behest of the mayor's office. He made his own decision, and for him, that decision was, I believe his exact words were, a no-brainer based on the allegations and Ms. Brinkley's position within the Animal Welfare Department. Moving on to the softer, more philosophical issues. Attorneys, as I stated at the beginning, act for their client. Their clients are held to their attorney's actions unless you can make some sort of showing that the client took diligent efforts to insulate themselves from the attorney's acts. To the extent that Ms. Durzo holds that the conversation between Mr. Grover and myself absolves Ms. Brinkley of any need to respond to the questions posed to her, that's simply not the case. Mr. Grover's responses should be taken as Ms. Brinkley's at that point in time. So to the extent that they refused to provide the information the city was seeking, that action is imputed to Ms. Brinkley. Even if information is available from a different source in an investigation, the city still has the right to ask that information of the employee and receive a full and truthful answer. If any employee is under investigation, the correct response to a question isn't, no, I'm not answering that, or a go pound salt, or you can get it somewhere else. The answer is the substantive answer to the question. There's no getting around it. There's multiple laws that spring from this. For instance, Garrity, they're compelled statements for a reason. The city as an employer can compel employees to speak to it. And if the employees do not provide a full response, there are consequences. Which leads to the last point. And there's no question that Ms. Brinkley had conflicting priorities here. She had her priorities with DMK and her desire to shield them from any further negative press, and her desire to shield the partner that they were working with from any sort of negative press. And those conflicting priorities come up against her priorities and her obligations to the city to answer those questions. And that's a hard choice, and it's a choice with consequences. Those consequences don't shield her from having to ask or from having to answer the city's question. Even she knew that there could be potential disciplinary action, and she still chose not to respond. At every correspondence I had with Mr. Grover and Director Navarez had with Mr. Grover, it was repeated. This is a condition of her employment. She has to respond to these questions. We believe it's relevant to the investigation, and she chose not to. At the end, this case is really simple. The allegation that she was insubordinate with Lawrence Rael, or the allegation that she was somehow mistransferring dogs, she was cleared of those things. The only thing that she was sustained on is the city asked her for information it believes pertinent to an investigation, and she refused to respond and was not helpful in her response. The first time she provided any sort of documentation from DMK that it wouldn't release that information to her was in her predetermination hearing, long after the investigator had requested the information from her. There's not even an aura of cooperation here. The nature of her position as an associate director of animal welfare is such that this sort of insubordination could not be tolerated. The director needs to rely on the associate director as their second in command for everything. Once that trust is breached, and once that person does not cooperate with them and refuse to acknowledge their authority, there's nowhere to really go from there in that relationship. Moreover, as the second highest in command in that department, she serves as an example for every single other employee. If a unionized employee came in and gave those responses, I'm not going to tell you, they would be facing severe consequences. And abrogating those consequences for Ms. Brinkley sets up a situation where the rules will be applied unfairly in the future. It's not okay to set up a double standard for someone who is at the top and then hold other employees to it. However, even if this board finds that termination is too harsh of a punishment, that doesn't change the fact that there is just cause for discipline here, and the board should, at the very least, reduce the disciplinary action in the alternative. I would be happy to answer any questions.
Okay. So we'll get a motion to close the meeting so we can go into closed
I'll
session.
close the meeting.
Second.
Okay. All in favor?
Aye.
Okay, so we're going to go into closed session. We'll reconvene shortly. We are now ready to reconvene the City of Albuquerque Personnel Board. During the closed session, we only discuss matters related to PB 19-04. So we are now ready to rule on this case. So if I can get a motion, please.
I move that we accept the hearing officer's report, subject to modification of her recommendation, but we accept the findings of facts and the conclusions. The recommendation, I move that we accept that Ms. Binkley be made whole for lost seniority, wages, accrued leave, benefits resulting from the termination. However, we modify the disciplinary action because we do find wrongdoing to a 15-day suspension without pay, and that she be reinstated to an equivalent position with the City of Albuquerque. Is there anything else? That's my motion.
A second? I'll second. Any opposed? All in favor?
You want to say what you're, no, okay. I'm in favor of my
So
own
that-
motion.
So it carries. Okay, are there any other matters before the board? Okay, hearing none, we will adjourn. Thank you.